and then get into some other conversations this morning. And we're talking about Ken Ofori Atta.
The big conversation.
On behalf of DHS.
And Mr. Jason, given that the nature of the issues that will be discussed during the bond hearing, are you requesting that the bond hearing be closed?
Yes, Your Honor. I'm glad you raised that. I was going to raise it. And for the record, I would just let, if I may, Your Honor. But
so the other issue is there's also a master calendar hearing, and I believe that given the nature of the issues, that sensitive subjects will be raised during the master calendar hearing. Are you also requesting that the master calendar hearing be closed to the public?
yes, and one clarification, Your Honor. We would like both hearings to be closed to the public. However, with respect to the bond hearing, we would like to have that held as soon as humanly possible to include today. I defer to the court in how to make that happen.
I understand. So,
okay.
So all the individuals who are in the WebEx, the matter is going to be held as a private hearing under United States immigration law. If either party requests that a hearing be closed to the public, under the circumstances, the court is going to close this hearing. So if anyone in the WebEx who is here to view this hearing, either the bond hearing or the master calendar hearing, you should leave the hearing now because we cannot proceed until you have left the WebEx. And no one other than the parties will be allowed to be present during the hearing. So, and if you're an attorney who has another matter before the court this afternoon, I will move you into the lobby so that the hearing on this matter can proceed. But again, anyone who is present, who is not one of the parties or is not an attorney on another immigration matter, should leave the WebEx. Otherwise, we will have to expel you from the WebEx. And so, Mr. Chasen, we're going to go off the record so that we can remove the other individuals who are in the WebEx from the hearing. And again, I urge everyone who is not associated with one of the parties or is not an attorney in another immigration matter, please remove yourselves from the WebEx. And we're off the record.
The conversation or the happenings in court yesterday. Of course, that was before the hearing began in camera. Well, Well, Ken Ofori Atta, Ghana's former finance minister, he appeared in a U.S. immigration court in Virginia yesterday, January 20, following his detention by U.S. Immigration and Customs Enforcement over what authorities say is an improper or expired visa stay or status. The hearing focused on his immigration status and bond conditions, and the court barred the public from attending. At the end, the judge adjourned the case to April 26 for the next hearing. The session was ordered to be held privately, meaning key details are not public yet. An immigration lawyer provided context on what happened in court and the legal processes ahead. We've been joined on the phone lines by some lawyers. Hamza Suhini Shaibu is private legal practitioner and the NDC communication member. Also, Austin Bracco Powers is another private legal practitioner. Gentlemen, thank you for joining us. Good morning to you.
Good morning, brother. I hope you are doing well.
Very fine, thank you. Thank you so much for joining us this morning. I'll start with you, Hamza. I don't know whether you monitored, proceedings, although it was in camera at a point, but you monitored how it started and the plea by lawyers for Ken Ofori Atta to have the session held in camera and all of that. From where you sit, in terms of how it looked like and in terms of the impact it has on anything, what do you make of everything? Hamza, can you hear me? Unfortunately, I don't seem to connect to Hamza Suhini, but we'll try and reconnect with him. I still have Austin Bracco Powers with me. Austin, can you hear me?
Yes, no, I can hear you.
Great. I can hear you loud and clear. We had a conversation yesterday about how different what is happening in the U.S. is from the extradition request or processes Ghana has started. And you explained to us it's not related in any way, but it may have some effect on the happenings in the courtroom yesterday. But Austin, talk to us from where you sit. What happened yesterday? Explain it to us.
So like you were articulated, let me say good morning to your listeners and those who are watching on social media, any of the social media platforms. Now, like we articulated yesterday, the immigration case, which is the case before the immigration judge, has absolutely nothing to do with the extradition process that Ghana has initiated. And I want your listeners to get this in mind. Now, with the immigration process that Ken is currently facing in the U.S. court, his appearance yesterday solely about bond. Now, about whether he should be released from detention. Like you will notice that earlier, his lawyers had made a request, which was declined by the judge. And this is another opportunity for the judge to consider some circumstances within which the judge will have to make a determination as to whether or not to grant Ken bail or not. So, in other words, so it was yesterday's hearing. It was purely a bond matter as to whether or not he's released from the detention camp or the detention facility, so that he would then be in his home and go attend to court hearing anytime he's summoned. Now, that is also different from the substantive matter itself. That is why he's still in the U.S. after the revocation of his visa. That is a substantive matter. So this is more like a prelude to the substantive matter, because he doesn't want to be in detention to exhaust the process. So he wants an opportunity for the judge to allow him to go home or rest or be with the family, so that as and when he is required or is needed, he will come to court. So yesterday's hearing was a different thing. And the thing is that during immigration hearing, the detainee has an opportunity to request for in-camera hearing. So, in other words, you can tell the judge, make a request to the judge that you don't want this hearing, particularly your hearing, to be made public. It is a right. In fact, it is something you can exercise. But before you exercise it, there must be some certain factors that you must meet. So first of all, the gravity of the case must weigh, it must be heavy. It means the substance of the case. And again, whether or not there's a political interest. Now you will notice that if you join the link yesterday, you will notice there were so many other Ghanaians and other people on the call.
True. I
should tell you that this issue has generated a lot of interest, significant interest. So it falls within the powers of the court to have granted him his request, because a lot of interest is at stake. Ghana is seeking, and I know I know some elements of the governing National Democratic Congress Party who also happen to join the court. So the interest. So you look at the weight of the case. You look at the interest, and whether or not there's an element of political persecution. So these are matters an immigration judge will have to take into consideration in deciding whether or not he or she would grant the request for in-camera hearing, and which yesterday the judge significantly did, and he did with their request. So it is in line with the right of strength. So it must be borne out of mind that this matter has just begun. In fact, it won't be an overnight conclusion. The conclusion will not be done overnight. It will take a while. It will take even some months for this matter to be concluded. And purely because we must let it think that it is only about immigration issues. The reason why he still stayed in the U.S. after the revocation of his visa, that is what he is in the immigration court for, and not because of the extradition process that we initiated.
I see. Hamza, good morning to you. Can you hear me now?
Yes, good morning to you, my brother.
Great. Thank you. Thank you for joining us. So, what happened yesterday? Councillor Austin has explained to us how different it is and how we may be rushing into some form of excitement when it will not or may not come as early as a lot of people are anticipating. From what you said, what do you make of all of the communication surrounding it and the thinking or the expectations people have of what is happening or ongoing in the U.S.?
I think, first of all, it is important to state that we cannot fault anybody for being interested in this particular matter, especially considering the evolution of the current ICE issues that Ken is having. Remember that upon assumption of office, this new government inherited many investigations that were ongoing from the previous administration. And one of such major cases had to do with the SML. And so Ghanaians, even prior to the election of His Excellency John Dramani Mahama, had issues with the SML arrangement. Many were already calling for investigations into that matter. And I guess that was the reason why the Office of the Special Prosecutor was petitioned to start work in relation to that matter. And so interest in Ken raged on even before this new administration came into office, especially in matters of accountability. So it is dangerous to create an impression that the interest is quite sudden. What might have heightened that interest in the affairs of Ken basically has to do with his refusal to come back to the country to face issues of accountability. Something that is quite strange to many Ghanaians, not just NBC supporters and NPP supporters. I think that many of us consider this quite strange, especially considering the fact that many of his colleagues are before lawful institutions in this country accounting for their stewardship in office. And so that is the reason why, if I'm to hazard a guess, why there seems to be that major interest in Ken's matter. So it is partially self-inflicted because of the path he chose. But like my brother indicated, what is happening in the United States of America is completely outside the control of the Ghanaian authorities. United States of America, just like Ghana, is a sovereign state. It is governed by its own rules and laws. And so if you are granted a visa to visit and you overstay the terms of your visa, the lawful authorities within that jurisdiction are mandated to reach out to you to ensure that you comply with the terms of your visa, failure upon which they can present you before any lawful court to fast-track your removal from the United States of America. And I think that that is what is happening. And it is not just in relation to Ken Ofori Atta alone. Many other people are going through the same process. Many of our Ghanaian compatriots are there, going through similar processes. But what I do know is that they give you ample time to justify your continuous presence in that particular country. And so I agree with Austin to a very large extent when he said that that determination rests squarely on the judge in applying the U.S. laws. But what they will also consider possibly would be the extradition request before the United States authorities now. In as much as this is an immigration matter strictly before the courts in reaching such decisions would consider in the remotest of senses many other factors, including the extradition request. I think that was the reason why it was easier for the judge yesterday to grant the in-camera sitting, because it is quite clear, like many Ghanaians are interested in it. And so in reaching that conclusion, I don't think that the judge was wrong, but it is not out of place, because you see, even as a government, we have always assured Ken that he will be taken through lawful authority. And if it is in the interest of Ken, as far as his eventual defense in Ghana is concerned, that many of these engagements in the U.S. be kept in camera from the Ghanaian authorities, why not? I think that it is within his legal right to do so. And we ought to respect that.
Right. And also, there's the bit also about the public communication in Ghana that could possibly have influence a certain extent, although it may be very small, a certain extent on the proceedings in the U.S. Comments from the Attorney General, comments from the Special Prosecutor himself that may be sounding like some form of political persecution in the minds of U.S. authorities. Don't you think we also have contributed in the cycle we now have found ourselves in, that Ken Ofori Atta may want to take advantage, although for the U.S. they may be doing what in their eye is very right and proper?
Excuse me, what comments are deemed political persecutions from the Attorney General?
The comments from the Special Prosecutor, for instance, that may be misinterpreted as a form of political persecution. You remember that Ken Ofori Atta himself has had cause to complain to Ambassador Victor Smith through his cousin that he's concerned about how he will be treated when he comes to Ghana. So if he makes an information like this known to the U.S. authorities.
You see, my brother, I think that I have made the point before on another platform that Ghanaians or state institutions in Ghana are not entrepreneurs of the fears of Ken. We are simply advocates of the rule of law. And so, until you are able to give me an example of a statement either from the Special Prosecutor or the Attorney General that seeks to suggest some form of political persecution, it is difficult for one to conclude that his worry stems from the possibility of political persecution, especially when we have many of his colleagues before lawful authority in this country. Indeed, and that's why I gave you that historical evolution of his troubles. It shouldn't be lost on any person. I think that we should not hide behind legalities. That Ken had a premeditated intention to avoid accountability in this country. That is not hidden. That is not hidden. But you see, as a responsible government, we understand that irrespective of our views, as far as his strategic move intended to avoid accountability is concerned, our responsibility as a government elected to uphold the rule of law is to ensure that we do not allow our personal views on the matter to cloud essential legal requirements. And so far, this government and state institutions have not conducted themselves in ways that suggests that indeed Ken will be politically persecuted, especially when he has not yet even appeared before any of our investigative bodies. I think that we should not give them the luxury of trading in what he terms fears that he cannot even point to specifics. We should rather concentrate on the legalities like I did in relation to the hearing we had yesterday. Regardless of my personal views about the case, I think that what happened in court was legal. I also feel that the processes being used by Ghana intended to get him before our lawful institutions are lawful means. And so it is not about the fears. When it comes to allegations of corruption or allegations of crime, victims in one way or the other will always have their fears. But our laws must stand. The NDC is not trading in the fears of Ken or Gabi or Tredako. We are advocating for collective compliance when it comes to the rules and laws of this country. That cannot be termed as political persecution.
I see. Austin, if you can still hear me, so this is the thinking, or this is the argument that is being made, that there has not been any proper evidence or proof of any attempt to politically persecute Ken Ofori Atta, so it does not even matter in the equation of things.
I think it will just be plain. I mean, if we'll do a great service to Ghanaians when we talk about when we'll be able to dabble in the truth. The thing is that the prosecutorial process of both the OSP and the Attorney General have created this atmosphere. So when Hamza says Ken had a premeditated inclination to run away, I don't get it. What evidence does he have? I think we need to speak to the fact. These are conjectures. If Ken, the evidence that we know is that he wrote to the then chief of staff that he was going to seek medical attention outside the jurisdiction. He did say he was running away. When the Hamza become a mind leader, the Hamza can conclude that by reason of someone writing an excuse letter, the person has given an intention to run away. I don't get it. We want to speak to the fact. The thing is that it is our work to look at the matters before us and to do due diligence. I think that the procedural process, now the way, if you look at the trajectory from the way the OSP handled this case, it is not out of place for Ken to say that he is scared, and he has not even said that he is scared to come because of the way they will treat him. It is people around him who are telling us. We have not heard that from Ken. But I'm saying that monitoring and looking at the trajectory, the process, the procedural process of the Attorney General, the OSP, it is clear, and even element of this level. Now, when they talk, when they speak, the conclusion is that Ken is a criminal. When they speak, you could see even their own supporters, the way they comment on issues, it is just to buttress what the larger party has been thinking about. That Ken is criminal, that Ken has engaged in. But mind you, the OSP has only conducted investigations. The investigations and the merits of these investigations are yet to be tested in court. So I have said that public commentary, that's why I have always been on the Attorney General to be cautious and manage expectations, because sometimes the comments we make and how we draw conclusions will feed into public perception. Then the people will draw a conclusion that this person is A or B, or this person is criminal or not. And when you're unable to secure conviction on a particular matter, then the people will say that you didn't do your work well. It is because of the way we build their expectation. We must let them know that in a court of competent jurisdiction, the opposing party or the accused also has an opportunity to be heard, and the accused can defend and rebut any evidence we think we have marshaled. So it is simplistic for Hamza to say that Ken is running away, and I have not seen any evidence to that. The government has not even given me any evidence. The Attorney General himself has not adduced any evidence to that Ken, by reason of he writing to the then chief of staff to go on medical leave, he has an intention to run away. I don't see it. So we must be clear. This Attorney General, the thing is that you came on the back of ORA, but the way they are running the activity, the way they are going about the activity, the aura, it means like it looks like they are being rather aura itself that they are taking to achieve. The thing is that you said you wanted accountability. Fair and square. Ghanaians support you. Personally, I support any attempt to bring Ken or anybody to face trial. But I don't support any attempt to create or prejudge a matter when a court of competent jurisdiction hasn't had the opportunity to do that. So, Amza may be doing politics to say that yes, Ken is running away. And it is within his right to do that because this is what the politicians normally do. They draw conclusions when there are no evidence. And to say that the Attorney General and the OSC have not done anything that's against an intention or anything that presupposes that this is more like a political persecution. Maybe he's not reading the room, but if he had read the room carefully, he would have drawn this conclusion.
Austin, thank you. Let me pick your final thoughts on this, Hamza. If you're still on the line with me,
you see, first of all, I was attempting to resist the temptation to at least refer you to the selective amnesia of my brother. In his earlier submission, he's accusing me of doing politics. In his earlier submission, you remember that as part of the reasons why he saw sense in the judge's decision to uphold Ken's application for in-camera proceedings had to do, in his own words, because some NDC people joined. That's when he introduced the politics into it. Ghanaians joined. You are unable to give a scintilla of evidence that suggests that it was NDC people who joined that led to a consideration of that particular decision by the judge. But you see, we are talking law. And since the promulgation of the 1992 Constitution, it has been clear, unless, of course, someone who is doing politics under the cover of being a lawyer, it is clear to any watcher of our democratic space that any time there are allegations of corruption against a former political office holder, there's the tendency for the other side of the political divide to raise issues of politics. Look, there were times the NDC, the persecutions of, what's his name? Prosecutions of former Cocoa Board CEO, Opuni and the likes. NDC had issues with it. But the likes of Opuni did not cook up reasons to run out of the country. And the fact that you have communicated to the new government the reason why you are out of the country does not mean that we should take your explanations hook, lines, and sinker. Because we consider many other variables in reaching a conclusion as to whether indeed your reason for absence are sincere or they are cooked up to achieve a certain end to it, attempting to avoid accountability. It is left for us to draw that conclusion. And when we draw that conclusion based on the evidence available to us, it does not mean that we are doing politics. And Austin needs to know that distinction. Ken might have, yes, undoubtedly requested through his cousin, who was president then, that he was traveling for medical release, treatment. Upon return, he would face the lawful authorities of the country. He has not returned. The country needs him to answer certain questions. He is unwilling. And it's been more than a year. And this is historic. He has not even faced our lawful authorities. He's avoiding the possibility of facing that lawful authorities. But as we speak today, he has found the energy and time to subject himself to another lawful authority in another sovereign country. That is the United States of America.
Right.
Why is it that he did not deem it appropriate as a measure of honor and respect to the Republic of Ghana to subject himself to same? What the Ghanaian authorities demanded. These are the questions we should be asking.
Right.
And so the intention as to whether indeed his absence is sincere or not is left on to many well-meaning Ghanaians to decipher. And I can tell you as a matter of fact, unless you are a pretender, everybody knows that Ken's intention not to appear before the lawful authorities of this country is not hidden. It is even the basis of the extradition request. And he is opposing that extradition request. And one of his reasons is the fact that he does not think that he will be entitled to fair trial in our country. injuring the international reputation of the Republic of Ghana, even as a former finance minister. And so these are the facts.
Right.
And when we state it, we are not doing politics. On one leg, we are trying so hard to protect the international reputation of the Republic of Ghana, because many other international organizations reference Ghana as an example of a working democracy. Today, Ken, by this singular conduct, is telling the international community that your perception about Ghana's democracy is a sham. What happens there is disregard for the rule of law, and we persecute political opponents.
Right.
When it comes to the concerns and complaints of political parties, anytime there's a change of government about political persecution, it has always been there. So what is different? What makes this particular case different?
Counsel, thank you. Thank you. Thank you so much for your time with us. Hamza Suhini Saibu is a private legal practitioner and an NDC communications team member speaking with us.